name is Carl Pearson, and I'm an attorney assisting homeowners throughout the United States in defending their home against foreclosure. You can see a list of my YouTube videos by searching in YouTube for CEPersVid, and I might show you this now. The middle one. That's like a trademark. You can find my videos by searching for that particular set of characters run together. Now, the history of attorney licensing. Until 1919 or so, there was no written examination for the licensing of lawyers in the United States. A lawyer declared himself or herself to be an attorney and started to represent clients at this point without any written examination by the state government. Harvard Law School, from which I graduated, was founded in 1817 and is the oldest continuing law school today. Many attorneys got their start by clerking, however, for an attorney, or by reading law, another word for clerking, instead of going to law school. Until the early 1900s, lawyers were given an oral examination by a local judge to determine their fitness for practice of law. But in 1919, California set up a board of law examiners to give a written test to persons seeking admission to practice law. And within a few years, this practice prevailed. It spread across the United States, with the taking and passing of bar examinations being required before admission to practice law. For years, the local courts made it difficult for a lawyer from another jurisdiction to practice law within the state, any state, with practices such as making tests easier for local candidates and various barriers for outsiders trying to practice law, especially in the retirement state of Florida, where many lawyers from New York and other states wanted to go to Florida, become a lawyer there, and then compete with the local lawyers, and Florida had its own way of dealing with that. With the growth of major law firms during the past 40 years or so, who often set up offices in the largest cities in New York, in the United States, it is common for lawyers licensed in one state, for example, New York, Pennsylvania, California, Illinois, Massachusetts, for example, to appear in cases in other states. This procedure is called pro-hac-vice admission, and you can see it at the bottom of the sheet here, pro-hac-vice admission. This is the way it works. To continue to pay lip service to the original requirement that a client's representation be by a lawyer licensed to practice law in that particular state, let's just pick California as the state that we're talking about, but that's just an example. The client would have to appear in a lawsuit with a local California lawyer, who we now call local counsel. The local counsel will then make a written application to the court for permission for an out-of-state licensed lawyer, such as a lawyer from Pennsylvania, New York, Florida, Illinois, or any other state other than California, to appear pro-hac-vice, meaning for this case alone, after asking the opposite side if they will voice any objections to the pro-hac-vice application. Objections are rarely made and would probably be rapidly rejected by the California court unless there was a real basis for objecting, such as that the lawyer has lost his or her license in his or her own licensing state, or is a criminal defendant somewhere, or as something else which questions his or her fitness to practice law anywhere in the United States. This application is usually on a form that the court supplies, or on a form that is readily available for any local lawyer to use to make application for pro-hac-vice status for the out-of-state lawyer. In fact, the out-of-state lawyer should be provided with the form and asked to complete it for the California lawyer, and then send the completed form with exhibits, including recent proof that the out-of-state lawyer is still a lawyer in good standing in the state in which he holds his license, and send this to the local lawyer for filing as an application or motion pro-hac-vice. As a procedural note, Out-of-state lawyers often have their names on the complaint even before any application for pro-hac-vice status is made. The rule generally is that a pro-hac-vice order must be granted, or at least an application on file, before an out-of-state lawyer is permitted to speak in open court or during a telephone conference with a judge or magistrate judge as an appearance on behalf of the client. Thus, shortly after the filing of a complaint with the names of the local counsel in California on the out-of-state lawyer, say New York, the California lawyer will wait until a lawyer appears for the defendant and ask the appearing defendant's lawyer to consent to a pro-hac-vice application for a certain out-of-state lawyer, or even multiple out-of-state lawyers, sometimes as many as 5 or 10 I've seen, to appear on behalf of the plaintiff. The defendant is able to do the same thing. The local lawyer will also call the opposing attorney and seek consent to a proposed pro-hac-vice application, which consent generally will readily be given. Then the local defendant's lawyer will file the pro-hac-vice application for the New York lawyer, and the case is ready to begin, sometimes with non-California lawyers doing most of the legal work. This procedure is becoming more and more typical among the largest law firms, but hasn't spread yet to the smallest law firms made up of individual practitioners such as myself. We should require this to change, and we can, and I'm willing to do it. I have appeared as local counsel in New York for clients being represented in their cases by non-New York lawyers, and my job then is to ensure that local rules are met to appear for the client when useful, so that the non-New York lawyer doesn't waste his or her time and money coming to New York for appearances that aren't too meaningful, and to review papers to ensure that they meet with local standards in various ways, including even the appearance of the paper, and to comply with local rules which differ throughout the country. Local counsel have a meaningful job to perform and need to be selected by a client to ensure that there is adequate representation by such local counsel. This means that local counsel will perform work that will require compensation, generally on an hourly basis. The role of the non-California or out-of-state lawyer is important to note. He or she, after the application for a pro-hac-vice order has been signed by the local judge, is the main attorney of record for the client and does not need to have local counsel appear thereafter. The appearing pro-hac-vice lawyer speaks for all purposes for the client after that order is signed, although sometimes an appearance by local counsel is quite helpful, and that has to be worked out among the clients and the lawyers. The newly admitted attorney via pro-hac-vice has the full power of an attorney admitted to practice in California, because for that one case, that is pro-hac-vice, the attorney is licensed in California to represent the client in that one case. I am willing and able to represent clients in defending foreclosure actions brought against them anywhere in the United States, or in bringing homeowner actions against lenders in what I call a homeowner's foreclosure action against the bank, using a pro-hac-vice admission for non-New York State cases. Also, I am interested in associating with lawyers anywhere in the United States to assist them in defending foreclosure actions or bringing homeowner foreclosure actions against a lender to stop the lender from foreclosing against the homeowner in the non-judicial foreclosure states such as California, New Mexico, Nevada, New Hampshire, Massachusetts, other states like that. Nevada, I hope I said that one too. I have numerous websites and videos relating to these subjects and invite you to read my website material at www.carlperson.com or look at my related videos. And here is my contact information once again, which I will put up here for you to see. It has my name, it has my website address, carlperson.com, my trademark CEPersVid, my phone number, and the phrase pro-hac-vice is spelled out for you. It's a pleasure doing this video. Thank you very much. And take a look at all my other videos. A lot of them are interesting, especially in the mortgage foreclosure area. Thank you.